Hey everyone, this is Leon from Prologue Projects. On this week's episode of 5 to 4, Peter, Rhiannon, and Michael are diving into some recent Supreme Court drama, namely the leak of some secret, decade-old memos to the New York Times. Back in 2016, the Supreme Court halted President Obama's Clean Power Plan in a 5 to 4 ruling that circumvented the authority of lower courts. The ruling has come to represent the birth of the modern shadow docket, which the court has been using routinely since the start of Trump's second term to bless various actions by the administration. Shadow docket cases are handled quickly and opaquely, without oral arguments or full opinions. The public is typically left to wonder why the court ruled one way or another. Thanks to the leaked memos published by the Times, we now have new insight into how the court justifies it. This is 5 to 4, a podcast about how much the Supreme Court sucks.
Welcome to 5 to 4, where we dissect and analyze the Supreme Court cases that have cratered our civil rights like final exams cratering our listeners' careers. I'm Peter. I'm here with Rhiannon.
Hey, everybody.
And Michael.
Yeah, why are you listening to us gossip about the Supreme Court when you should be studying? Listener.
We know that some of you are law students. It's late April, early May when this drops. You're about to bomb, dude. You're about to fuck it up because you're listening to 5 to 4. What are you doing? What are you doing? Oh, my God. You need to start freaking out. It is time to panic.
What if you let the anxiety spike right now? Yeah.
Yeah, just let it take you.
Here's some facts. It's too late to fix it.
Not true. Not true. Y'all are going to do great.
By extension, it's too late to fix your career. It's over for you. It's over.
Start thinking about what you're going to do to recover from the damage you're about to do.
And there's no more space for a law podcast. So
yeah, that's right. You might think, well, maybe I go into law podcasting. No, bitch.
Like those 3 deadbeats did it.
Yeah.
No.
We filled up the space entirely between us and advisory opinions.
The market
There's
is
no
saturated.
room left. Today, we're talking about an interesting bit of reporting out of the New York Times. This is something that we would usually do as like a premium episode, but we thought, fuck it, right? Let's just talk about this. About 10 years ago, the Supreme Court halted an Obama EPA policy without any briefing, without any argument, without even letting the issue get properly litigated in the lower courts. This is often seen as sort of the spiritual beginning of what we now call the shadow docket, the emergency docket that has come under scrutiny in the past few years because the court has increasingly used it to decide politically charged cases without any briefing, without any argument, often without any written opinions. We previously did not know much about what happened with this particular case, but someone somewhere, some beautiful hero, leaked internal court memos to the New York Times containing the discussions some of the justices were having, and it is very revealing stuff. Before we get into this, I want to say you could leak this stuff to us instead of the New York Times, and it would be cool. I think we all agree it would be cool.
Our DMs are open.
We'll protect your identity or whatever, you know, whatever like the cool journalistic ethics thing is to do there. We'll do it.
We're on Signal. Yeah.
Yeah. No, hit us up on Signal or other secure channels. I'm sure there are others, but no, we'll take care of. We'll protect you. We'll go to jail before we out you to the DOJ. All right, so let's tee this up by explaining this case from 2016. Back during Obama's second term, the Environmental Protection Agency implemented the Clean Power Plan, which would require certain polluters to significantly reduce their carbon emissions by 2030. The plan gets challenged in court by some industry types. That court specifically, the D.C. Circuit Court of Appeals. The industry folks ask the court to put the implementation of the Clean Power Plan on hold while the case is being decided. The court says no, but that they will expedite the proceedings. The industry types then go directly to the Supreme Court and ask them to halt the regulation, and they did. If any of this sounds vaguely familiar, this ends up being West Virginia v. EPA, a case that I believe we've covered.
Yeah.
You know, it's about this EPA rule to limit emissions. So this is not the first time that the Supreme Court used their emergency docket but it is in various ways unprecedented. It was the first time that the court had ever halted a federal agency regulation nationwide before a lower court had even reviewed the issue.
Mm-hmm.
This isn't a situation where the lower court ruled and the parties appealed exactly. The case was still pending in the lower court, and the parties directly petitioned the Supreme Court to intervene and stop the regulation. This was all a little bit procedurally odd, right? The parties go to the lower court to try to halt the regulation, to have it paused, basically. Lower court says no, and they don't appeal directly, right? They just go to the Supreme Court and ask them to do what the lower court didn't. That's a minor item in some ways, but it creates a weird precedent where parties can essentially ignore the lower court, go straight to the Supreme Court, challenge the regulation there, and it makes the Supreme Court, at least theoretically, a sort of one-stop shop for this sort of thing, right? And that's sort of what has happened. That's what has developed over the last decade, is that parties will just go to the Supreme Court as quickly as possible and be like, can you halt this regulation? Can you prevent the government from implementing this, right? Before lower courts have any time to act.
Right. If you're Republican. And
if you're a Republican. Well, you can ask. You can ask if you're a Democrat.
Yeah.
Before this, the emergency docket primarily used for death penalty cases, election issues, things that need input from the highest court possible very quickly, right?
Mm-hmm.
Not exclusively used for those things, but like those were some of the primary purposes. But from this point forward, in 2016, it's increasingly used as a arena for adjudicating federal policy.
Yeah, and what you're saying, Peter, like this is like the start. This is the birth of it. So leaked memos. What did we actually learn? What are we talking about here? So on April 18th, the New York Times just released these memos. They were leaked to the Times. The headline reads, "Read the Supreme Court's shadow papers." So what are these memos? These are memos between Chief Justice John Roberts, Elena Kagan, Sonia Sotomayor, Stephen Breyer, Sam Alito, and finally Anthony Kennedy. And the fact of their communicating in memos is not abnormal. This is normal. Justices typically communicate with one another in written memos like this. This is how they discuss cases, discuss the arguments that they think are important. This is how they figure out where like the contours of the legal debate are amongst themselves. And they also try to write persuasively to like maybe get a swing vote like Anthony Kennedy to join up with either side. So what the unique thing is here is that memos are generally not released to the public. We don't usually see them. They're recorded, like they're archived, they're kept in the justice's papers. Usually, though, they're kept secret unless a justice decides, usually like upon retirement or death or whatever, to release their own individual papers. So that's the unusual thing here, is that in this case, on this shadow docket case that started the sort of like modern or more recent understanding of how the Supreme Court uses the shadow docket in these really political ways, it's that we have some of the justices' memos about this case leaked here to the Times. You know, other than like oral arguments, other than the literal written decisions of the Supreme Court, the public doesn't have access to this info. And then for this case, which is on the shadow docket, there wouldn't be oral arguments anyway, because it's part of a case or in the procedure when the court is being asked to rule on something very quickly on an urgent basis. There aren't like full arguments in front of the court. So we wouldn't even have oral arguments to listen to anyway. And with the shadow docket case, there isn't necessarily a written decision. So these leaked memos represent basically all that we know now about how the justices were thinking about this case.
And we're going to go through what each justice said, why so much of it is so notable. But first, a quick overview of what plays out here. Roberts refers this matter to the court, and he says, hey, I think we should stay this regulation. Stephen Breyer responds, disagreeing. Roberts responds to him. Kagan and Sotomayor weigh in on Breyer's side. Alito joins Roberts' side. And then finally, Anthony Kennedy, sides with Roberts, which really ends the issue because it's a 5-4 court.
Mhm.
We don't have memos from the other justices. Very possible that the leaker didn't have access to them.
Mhm.
Also possible that they weren't interesting enough to include, although that seems less likely. And it's also possible that they just didn't weigh in on this issue, which I also find relatively unlikely. That's sort of the overview here.
Right. And so we should talk about Roberts because he writes the most. He writes multiple memos. They are long. They are substantive. They are very bad. And he looks like shit. So it's worth going through them.
Mhm.
He looks bad for a number of reasons, and we'll get into detail on all of them. But the high level picture is that they're very sloppy. He uses a wrong standard. He cites to blog posts and interviews and things like that are not appropriate for Supreme Court decision making, right? But also, I think something that comes across is he's just kind of pissed about a previous case with a mercury rule where the EPA had promulgated this regulation. The Supreme Court ultimately found it unconstitutional. But as it turned out, by the time the Supreme Court had reviewed it and held it unconstitutional, industry had made such an investment in compliance that it was all but baked into standard practice at that point. And Roberts is clearly livid that they essentially didn't get to stop this, right? That the Supreme Court was just too late in time to prevent the nasty libs from keeping mercury out of your drinking water or whatever the fuck this case was, right?
Yeah, that's Michigan v. EPA, which we've also done an episode on.
Yeah. And so he's like, what's going on here is he's just like, I don't want this to happen here. Just somebody who's very frustrated that they don't get a bigger or earlier say in policymaking and the shaping of the economy. Right? Basically, because they're the court of final review and litigation takes a while. Building a record takes a while. Going on appeal takes a while. Taking things en banc. All that stuff takes a while. By the time it gets to the court, wow, industry will have complied with this and maybe started to shutter some coal plants and maybe started to build some solar plants.
Right.
And
although keep in mind the lower court had expedited the proceedings. So
right. No, this was
going to be resolved in 3 months.
Right. And the government had created opportunities for extensions. We'll get into this when we'll talk about irreparable harm, but there's reasons to believe he's exaggerating the risks here regardless. But that's sort of what he's angry about.
Yeah.
We should get into the details of how he's sloppy. It starts with him invoking the wrong standard in regards to stays. He cites the cases that detail the standard for stays of lower court orders, lower court mandates. That's not what's being asked here, right? There is no lower court mandate for them to stay. They're being asked to stay in EPA policy.
From going into effect, yeah.
Right.
Roberts is trying to use the standard that the Supreme Court would use in order to stop a lower court's stay from going into effect. That standard where they talk about would this cause irreparable harm to one of the parties in the case, that kind of stuff. That standard is about reviewing a lower court's ruling, which hasn't happened yet. And you see this in the memos. Kagan says, hold up, the standard that you're proposing, John Roberts, this would be an unprecedented use of that standard in a case like this, where there is no lower court ruling.
Even calling it a stay, it's sort of awkward. It's like a procedural artifact. They're halting an EPA policy, right?
Right. Mm-hmm. Based on nothing. Based on, no judicial fact-finding, no briefing, or the barest of briefing, no argument.
There's no factual record at all.
Based on just, 5 conservatives' gut feeling that this is unconstitutional, they're saying the government can't do it, right? It's very, it's just way out over their skis here. And Kagan objects, and Roberts admits, he says, I recognize that the posture of this stay request is not typical, but review is sought of what has been described as, quote unquote, the most expensive regulation ever imposed on the power sector. So,
right.
This is pretty extraordinary, but our buddies in industry don't want to shell out. So,
yeah. So this is interesting to me because it undermines two of the most common defenses of the Supreme Court's use of the shadow docket in recent years. First, a lot of people are like, nothing has really changed here. Like, this docket always existed. The emergency docket always existed in some form. Maybe they use it a little more, but like, this is a fake controversy, right? There's nothing sort of out of the ordinary here.
Mm-hmm.
And some people build on this by saying, this is really because you're seeing more executive action, because Congress is inactive and blah, 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 right? And then the second argument is that there's really nothing to worry about regardless because this is all procedural shit. It's not political. The court, is just doing balls and strike stuff, right? That classic defense of the Supreme Court where they're just like, well, look, this is all procedural stuff. You don't need to worry about it. It's not like hyper political. That's just what the haters say. And then you have Roberts here just being like, look, this is unusual procedurally, but we have to do it because the policy stakes are too high.
Yes, like this total tell, right? He's saying like the basis of his argument or the justification for why this is so important and why the Supreme Court has to step in here is that it's an extremely expensive regulation, that it's going to cost power plants, the power industry, money. That's Congress's power to decide. That's the EPA's, right?
Right. It's very odd. It feels like an obsession with cost that you would never see them do for like, oh, this is going to cause human suffering in the real world.
Yeah.
Right. I think that's a good segue to talk about his irreparable harm analysis, because that's part of the decision making is when you stay in action, when you enjoin the government, things like that. Part of the analysis is, well, if we don't do this, will there be harm that can't subsequently be repaired, right? Mm-hmm. Typically, monetary outlays are not irreparable harm because they can be repaired by giving people the money.
Right.
It's shocking. Money is fungible, and you spend $10 now and you get $10 later. You're made whole.
Yeah.
So it's a weird thing to be focused on when you're talking about irreparable harm is costs. Costs are, by definition, reparable harm.
Mm-hmm. But that's if you look at just dollars and cents. If you look at the love of the game, they want to blast coal fumes into the sky.
Right.
Right. And if you pause that, if you press pause, you say, hey, you can't do that for a few months. Those are birds that might live, right? Those are are streams that might run clear for a few months. And you can never get that back.
That's right. Ostensibly, it's about preserving the status quo. But then the question is always, what is the status quo, right? Mm-hmm. Like Roberts is saying he wants to preserve the status quo of the structure of the energy sector. Right? As if that is the only status quo that matters, and not like, for example, the fact that the regulation is in effect is the status quo. And so you're not preserving the status quo, you're upending it. Mm-hmm. Or the fact that X amount of coal is in the atmosphere, and if we don't stop coal plants from pumping more in, there will be more coal fumes in the atmosphere, upending the status quo of how hot it is, how unstable our climate is. No, we're not preserving the status quo of the climate, of the livability of our planet. We don't give a shit about that.
Yeah.
The only status quo we care about is how power companies allocate their resources between renewable energies and fossil fuels.
Right.
That's the only status quo he gives a shit about, which is really fucking just blatantly obvious and just sort of disgusting, right? And so, in addition to this like shitty irreparable harm analysis, I also mentioned before, he's citing to statements that like the EPA administrator like made off the cuff. And he's basically citing like a BBC article, and like a blog post that was like on the EPA's website.
Yeah.
And these are the things that he's like upset about, which feels very like, he got some email, subject line, forward.
Well, so the BBC article was just in the industry brief, or like one of the briefs. Right. So there's no factual record, right? But the industry types are just like, well, look what the EPA is saying. And he's like, oh my God, look what the EPA is saying. But like, in theory, like the best practice would be that they don't consider stuff like this because it's outside of the factual record. And in fact, there is no factual record here.
Right. Like a lower court might develop a record where it turns out what the EPA administrator said was wrong. Like was just incorrect.
Right. I saw a defense of this on SCOTUS blog, which I will talk about a little bit later, but where someone was like, well, look, this is actually quite common. If you read memos, the justices will often consider things outside of the record. And I was just like, well, that's worse then, right?
Yeah.
It's a lot worse if it's not a one-off.
They shouldn't be doing that.
Like, and you just get this vibe. It's not just the BBC article aspect of it and the blog post aspect of it, but that's part of it. You just get this vibe that this is just like some people arguing via email, right?
Yeah.
And it's not very sophisticated. They don't really know what they're talking about. Like no one understands these regulations or these industries. And they're just sort of like sniping off little rejoinders. And like none of them are very compelling. And like they just don't have their arms around these issues enough to be compelling. You're just like, this is the fucking Supreme Court. And I think this is like a huge element of what made this leak interesting. Because we've seen memos before, but most of that is just justices making their memos public. And because of that, it's often favorable. They often look pretty good in these memos. And now you're seeing them hash out this contentious issue, and it's like, these are our top dogs here.
Yeah.
You can see that they're like stuck thinking about the procedure or like trying to shoehorn what they think about this case in their own minds into the procedural arguments, the precedents of, of taking this case and making this decision in the procedural posture that it's in. And so they're making like procedural arguments, but you can tell behind it, they're thinking other things that they're not asserting, right, in the memos. So like on the point that John Roberts is making this big deal about the irreparable harm that will fall onto the power industry if they don't step in and stay this regulation. The libs, I think, like they have the correct argument, which is no, irreparable harm is not going to happen. It's not asserted like super passionately or strongly or anything, again, because I think they feel like they're stuck on a few like bare facts. But Breyer, Kagan, and Sotomayor, all three of them are like essentially in a lib justice way, essentially like, wait a minute, what are you talking about? What is the irreparable harm? And they all bring up like just like basic facts about the process, about the procedural posture of the case, which is, as we've mentioned, the DC Circuit Court said they're going to rule on this on an expedited basis. You're waiting a matter of a few months for a ruling here from the lower court. And then the next thing, Kagan and Sotomayor both talk about this in their responses and their arguments against John Roberts, that even within the regulation, even with the plan or the rollout of the regulation, if it were to go into effect, the parties, the states, can all ask for a 2-year extension during which they don't have to do anything. They don't have to implement, they don't have to take any action under the new regulations. Private parties, so the power companies, have 6 years before they have to do anything.
Yeah.
So Breyer, Kagan, Sotomayor, all three of them are like, what irreparable harm are you talking about? Nobody has to do anything.
Right.
At least until the DC Circuit Court of Appeals has a decision, and not even for years afterwards.
Yeah, and the reason those years work out like that is because the EPA isn't even requiring anything of private industry. They're requiring states to promulgate regulations that will then impact private industry. And the states can get a 2-year extension to do that. So they would have 2 years. So the private industry wouldn't even have their regulations that they need to comply with to worry about for 2 years, and then would have lead time after that, which is why the idea that this needs to be done now, right now, Roberts is like freaking out about, is so laughable.
Yeah. And my main complain about the libs approach here is that they get into a fight about whether this would actually hurt industry and how much. And I do think they're right that, like, Roberts is like, look, the coal industry companies are saying that they might have to shut down plants if we don't do this. And then Breyer's sort of like, yeah, but given this is only going to take a couple months to litigate, does that actually make sense? Like, trying to be like,
Yeah.
do you believe him though? Right?
Yeah.
But I think the actual point that should be made is the one that, Michael, you made, which is like, if you're weighing the harms, on one side, the industry is saying, oh no, we're going to lose money, which they can just be paid back. And then on the other, it's damage to the environment, which can't be readily repaired. So like only one side of this equation is going to suffer irreparable harm, right?
Yeah. Again, kind of getting stuck in the process and not really making the argument that they should make. All three of the liberals are, again, accurately pointing out how unprecedented a move this would be procedurally, right? Kagan says, like, the unique nature of the relief that is sought here gives me real pause. You know, Sotomayor says this is unprecedented. Breyer says this is unprecedented. This is acting way prematurely for the Supreme Court. Kagan says, you know, the Supreme Court is the court of final review, not initial review.
Right.
We don't review things as if we're the lower court, as if we're a district court, right? Like just getting an issue for the first time and being the first court that rules on something. So all three of them, like, very insistent that, like, hey, Chief Justice, like, what you are proposing is pretty wild. This is crazy just procedurally. But again, it's like, you know, it's kind of these short paragraphs, you know, nothing really is more than 2 pages here. So that impact, or like really how unprecedented it is and what the consequences would be of opening up this process on the shadow docket, like, they don't engage that at all, at least not in these memos.
Yeah.
Right. So Sam Alito weighs in on this too. A lot of his memo is just about the same, like, I believe the industry when they tell us that they're going to suffer.
He says something like, I wholeheartedly, passionately agree with everything that the Chief Justice said.
I will suck on an exhaust pipe if I have to. But then he also says, quote, a failure to stay this rule threatens to render our ability to provide meaningful judicial review, and by extension, our institutional legitimacy, a nullity.
Mm-hmm.
So, like, you know, you're bullshitting when you say that your institutional legitimacy is completely dependent upon doing a thing you've literally never done before.
Never. Unprecedented
right?
in the
that feels
history
like
of the Supreme
almost
Court.
Impossible as a matter of logic and theory. I'm not like a philosopher, but it doesn't feel like it's logically possible for that to be true.
Yeah.
It's ridiculous.
And then the final memo is just Kennedy weighing in like a short paragraph from his little throne atop of the 5-4 court, being like, I agree with Justice Roberts.
Yeah.
But it is such a tell what Kennedy says, just again, in a few short sentences. You know, he's saying, like, yeah, I'm finally convinced I'm going to come down on the side of the conservatives here and basically rule for the court, because he makes it a 5-person majority. He says, you know, in this memo, he's saying basically, I think what's going to happen in 4 or 6 months is that a stay is going to be issued. And, you know, the way this reads, very short few sentences here, the way this reads is he's either saying we, the Supreme Court, are just going to issue
the future.
A stay in 4 or 6 months anyways, or he's saying the lower court, which is taking up this question on an expedited basis, will issue a stay in a few months, and then we'll be reviewing that anyways. Like, either way, whatever he's saying, it's so ridiculous. Like, why are you predicting the future about what a lower court is going to do, and then about what the Supreme Court would do after that?
Without a factual record, without knowing what the facts are.
And inserting the Supreme Court into making the decision that you say the lower court is going to make. And in fact, according to all this history of process, the lower court needs to make in order for you to review it.
Yeah.
So those are the memos. And obviously, this caused a stir. The New York Times piece is pretty critical of Roberts. They say that he bulldozed the court. They seemed caught off guard by like the tone and tenor of the memos, right?
Mm-hmm.
They got a little bit 5-4 pilled
Yeah, that's right.
in reading the memos. They were like, wait a second, this is just a bunch of fucking idiots. Like,
Yeah.
what's going
Yeah.
on here?
Mhm.
Peter, you got Adam Liptak to issue a correction, and now he's like,
I changed
5-4.
his whole life.
That's right.
I got him to issue one official correction, and he's like, you know what? I've been thinking about this all wrong. He's wearing the I dissent shirt.
Yeah.
I think there's a few things in this. One is that like the conservatives are just sort of like deferential to what the industry folks say in their briefing, right? The industry folks are like, we're going to be harmed. And they're like, oh, okay. Well, if you say
Yeah.
so.
Yeah.
And then they're just doing this half-assed analysis. Roberts is getting the fucking standard wrong, right? And no one even notices, by the way. No one's like, that's not the standard. And I think it just all feels so weirdly amateurish that if you thought highly of these folks, you might be like, huh, maybe I made a mistake in trusting them with our democracy.
Yeah. Maybe we're not sending our best.
There's sort of that implicit criticism in the Times piece. There's some explicit criticism in the Times piece. And it led to a lot of like chatter online and criticism of Roberts. And naturally, this has brought out the Roberts defenders, right?
Mhm.
And so I think we need to walk through them because it's funny, because it's fun. Watching these schmucks try to defend it all, I have to say it's been very enjoyable.
Yeah.
I've really enjoyed it quite a bit.
Yeah, all the ghoulish, clownish little fools coming out to comment, to defend, Daddy John Roberts and how
Mhm.
smart he is. I promise he's smart. Molly Hemingway, conservative author. I think she's editor-in-chief of The Federalist, Fox News contributor, talking head kind of gal. She tweeted her thoughts about the leak. And I think kind of funnily, she doesn't defend John Roberts. She attacks the leak, implies that it is an ethical violation,
Mhm.
that whoever leaked the memos should be reported to the bar, right? Have an ethical inquiry into whether they, failed in their professional responsibility as lawyers. Of course, we don't even know if the person is a lawyer. I guess we assume that the person is a lawyer who leaked it, because why else would they have access to these things? But it's not necessarily that they are a lawyer. Anyways, Molly Hemingway's response is, how dare you?
Yeah.
How dare you leak these
Mhm.
things in which my king, John Roberts, could be criticized?
Right. Criticism of the leaker is always the most boring
Yeah.
type of criticism, because it's just like, we just found out about these like behind the scenes deliberations in this relatively important case, even if you don't care about the environment, right? And you're like, someone somewhere has violated an ethics rule. Like, who gives a shit?
Yeah.
Who gives a shit? Who fucking cares? I mean, obviously our position is that leaking this sort of stuff is cool, that like,
Right.
it's inexplicable to me that this shit isn't public, that they just get to hide their little internal memos forever. It's why
Right.
aren't we allowed to see it? It's obscene. But like, even if you think they deserve this privacy or whatever, at most it's like, okay, who cares? And also, if you think that this is all very inoffensive, that nothing untoward happened here, don't worry about it. Don't worry
Yeah.
about it.
Yeah.
Yeah. The people upset about this are very funny. Their anxieties and their defenses, in a way, are showing all their cards, right? Like Josh Blackman over at the Volokh Conspiracy, which is a sort of conservative / libertarian right-wing legal blog. He talks a lot about how he contrasts this to the Dobbs leak, right? The opinion that was overturning Roe v. Wade, where he's like, whether you think that was a conservative trying to lock in votes or a liberal trying to shift votes, that leak was clearly about affecting a case that it was like pending. And he's like, this is a 10-year-old case.
Yeah.
He says, remember, the movement is being led by people intent on showing that the Supreme Court is a failed and illegitimate institution that must be reformed from the outside. If they're outed, it may boost their career. He's upset. He's upset that this is so effective at making the Supreme Court look like shit, right? Because the Supreme Court is their tool, their legitimating tool for enacting their policy. And he's like, He's like, look, this makes us look bad, right? Right? That's like, that's what he's upset about. He's upset that this makes us look bad. And what's more, like, the leaker would probably be considered a hero for doing it if they're ever
showing
out.
a grotesque misunderstanding of liberal circles. Because like if like a right winger leaked it for the benefit of the right wing political project, yes, they would be handsomely rewarded. This person is going to be executed by hand by Barack Obama himself if they ever find him.
Another guy at Volek, John Adler, like speculated a bit about who the leaker was and suggested it might be Sonia Sotomayor clerk or even Sotomayor herself, based on very thin evidence, basically that there's a typo in Sotomayor's memo and she didn't sign it. So he suggests maybe this was a photocopy of an uncirculated draft.
Let's get Ed Whelan on this.
Yeah, seriously. Let's bust out fucking Google Maps. There's all sorts of reasons to think this is bullshit. Steve Vladeck pointed out that like the typo in the date suggests maybe it was February 6th, not February 16th, which would put it on a Saturday, which means like you wouldn't be surprised that like this is maybe being dashed off without a signature, maybe just sent an email with typos because it's not a full workday with clerks and all that to proofread everything. One possible explanation. There are many others, right? Another guy at Volek, I'm just going to tell you, the title is Court Leaks and Attorney Journalists, the Professional Ethics Implications of Making Court Confidences Public. And he wants to go off on like why people should be disbarred for even publishing these things. Like, fuck the leaker. Like, if you have a byline on this,
it's such a tell.
These guys are so fucking pissed about this that they're like, if you even write about this, maybe you should be disbarred, and everybody involved should be disbarred.
Again, this is just decade-old memos about an issue that's like dead. Like,
but it makes them look bad, right? And they admit that this is fodder for Supreme Court reform, which they don't want. They don't want because the Supreme Court is their biggest tool for implementing conservative policy and legitimating it, or at least it used to be. They read the same polls we all do. They know the Supreme Court's legitimacy is in the fucking shitter. Thanks mainly to 5-4.
Yeah, mostly.
I take full credit for that. Yes.
What's up, everyone? It's Leon, here to tell you about how I've transformed my morning routine thanks to Huel. Used to be, I would wake up, take my daughter to daycare, then come home feeling already behind on the day's work. So behind that I would skip breakfast and before long, find myself sitting in front of the computer, helplessly hungry and completely pissed off. That was the old me. Now I drink Huel's Black Edition, a complete meal in a bottle that comes in a bunch of flavors, including my favorites, iced coffee, chocolate, and strawberry. I throw one of those back and I'm instantly up 35 grams of protein and 27 essential vitamins and minerals. And best of all, I'm in a good-ass mood. Sometimes I go for Huel's other big-ticket product, the customizable powder that you can mix with water and ice for a smooth, refreshing blast of protein that comes out to less than $3 a meal. If you want to get like me, check out this limited-time offer. Get Huel today for 15% off at Huel.com/54 and enter promo code 54. That's 54, all spelled out. New customers only. Thank you to Huel for supporting 5-4.
Now, one interesting media player here is SCOTUS Blog. SCOTUS Blog is really like the preeminent source for Supreme Court coverage. It's a great source for Supreme Court content generally. If you're like hunting for briefs, they have everything. But not long ago it was bought by the Dispatch, a right-wing media outfit. Like Jonah Goldberg runs the Dispatch. That's how right-wing. These are like National Review, Weekly Standard alumni.
Yeah.
Now, there were multiple commentary pieces about this in SCOTUS Blog, all defending Roberts, I think. They just changed their web format, and it is impenetrable. So I'm not actually sure that I found all the commentary. It's they've made it much worse. Minor logistical concern I have. I have a couple of highlights from these posts. One is from Tara Lee Davis. And she's talking about the memos and like how the justices sort of ultimately decided in this case. She says, whatever you think of the outcome, the memos do not show a court plucking a result out of the air. They show justices citing precedent, applying the four-factor framework, and debating whether to wait for the D.C. Circuit to act. Of course, one can disagree with the precedents the justices invoked or with how they applied them. But the deeper question, why the court granted the ask and why at that moment, the memos do not resolve. So like, as long as they cite some precedent and like go through the motions of debating it, she's okay with it. And also she's like, they apply the four-factor framework, but she does not mention or perhaps not notice that it's the wrong framework, that they're doing the wrong analysis.
She's arguing against a position that doesn't exist.
Right.
Like the memos don't reveal that the Supreme Court justices don't debate the issues, cite precedent. That's not what the memos reveal. And nobody's saying that. Nobody's saying like the judges aren't talking about the law here. Mm-hmm. What the memos reveal to anybody with a brain, to anybody who's literate, other than Jill or whatever you just said her name is.
Tara Lee.
Oh, okay. Tara Lee. Well, Jill, Nicole, Tara Lee.
The image that fucking pops into my mind is just like a white box with like factory made, like, you know, cake with black icing on it.
Yeah.
Or something. When I hear Tara Lee, just like.
Yeah. Well, yeah. Jill, Nicole, Tara Lee, whatever she's saying, like she doesn't get this, but you're making an argument, scrambling to make an argument that's like, no, they're legitimate. No, they're doing exactly what they're supposed to be doing. No, they're acting like judges. And nobody's saying they're not acting like judges. We're saying they're being stupid in acting like judges. And we can see behind these sort of bare, very shallow procedural arguments, we can see behind these things into what they actually think on these issues.
This is like watching someone pretend to type on a keyboard and being like, they're working. Don't worry. They're working.
Right.
Yeah. There's another piece by Stephanie Barkley that basically makes this argument that's like, well, this has happened before. This isn't the first time. This isn't the beginning of the shadow docket. But her examples are all off the mark. She cites a case from 2013 where the court said the government can't enforce a regulation against one particular party, which is different from what happened in this case where it was the regulation in full being halted, right? But also, like, who gives a shit if this is like actually happened before, right?
Yeah.
I've seen this argument pop up in different forms where people are like, well, the court has done similar things here, and here. And you can you can dredge up some similarities between this and what the court has done in the past, of course, right? It doesn't really matter. You know, it's sort of a spectrum, right? It's a spectrum of behavior that we're concerned about. Steve Vladeck wrote that whole book about the shadow docket, and he writes about this where he's sort of like, you know, there's not a definitive time where you can say, oh, we crossed the threshold and it's the shadow docket now, and it used to just be this really normal emergency docket.
Sure.
That's not what's happening. It's about like how this emergency docket is being used, and you see these sort of patterns emerging, right? And this is this one moment in history where people are like, yeah, this looked like maybe it was sort of spiritually the beginning of this, right?
Yeah.
The last SCOTUS blog piece I want to talk about, and I want to be clear, this is not all of them, is by Jack Goldsmith, a name I've seen before, but I don't have any recollection of him. Michael?
Oh, he wrote the warrantless wiretapping memo in the Bush administration.
Yes.
But is nonetheless beloved by liberal legal types because then he resigned after the torture memo. He's like, warrantless wiretapping, I'm good. Torture, that's a step too far. And people are like, wow, he's so principled.
Hero.
He was also one of the guys on the Biden Supreme Court Reform Commission who wrote like a statement being like, I do not agree that we did not say fuck Supreme Court reform in our report. Like, I wrote a separate statement. He's such a loser.
To save face. Yeah.
Goldsmith says, quote, without any support in the documents, Cantor and Liptak say the Chief Justice seemed, quote, angry and irritated in the memos, and they portray him as an almost bad faith actor.
Yes.
Right. So when Roberts halts a federal regulation based on like a hunch about what will be good for business, right?
Right.
That's like proper decision making. But when some journalists try to read between the lines to interpret Roberts' tone or whatever, they've crossed a line. It's game over for these motherfuckers. How dare they? How dare they? He says, they mentioned that the Chief Justice's legal analysis for the order rested in part on the major questions doctrine that, quote, in the years since has played an increasingly important role in the court's work. Since their central message is that the conservative majority led by the Chief Justice is unprincipled and outcome-driven, they might have mentioned that 2 months ago he wrote an opinion for 3 conservative justices that invoked major questions to strike down President Trump's signature tariff policy. So the entire argument here is you think they're conservative, but what if I have one case where they ruled against President Trump?
Right.
Where they also happen to side with industry. Again, it's incredible.
Right.
And it's like he's like citing, he's like saying like they're citing the major questions doctrine, which has been used to decide really important cases. It's a doctrine that John Roberts made up.
Right.
It's the major questions doctrine is John Roberts' baby that came from his stupid head that John Roberts has now used many times. Right? Like,
I just don't like, I feel like I keep saying this on the show, but like, it's wild how many times you'll see this if you're looking for it. When there's 10 cases and they rule against Trump on one,
right?
That doesn't just negate the other 9. Like,
right. When he's winning 90% of the time, we know what that means.
Yeah.
Which is he sticks to the law very, very rigorously, of course.
Right. This is just like, I don't know, like if like every person has like one issue where they're not like aligned with their party or their ideological cohort or whatever, right?
Right.
You wouldn't be like, oh, AOC's not a Democrat, like not on the left because she has this one position, right? It just doesn't make sense. No one thinks about the world this way. It's nonsense.
Yeah.
Right.
Yeah. They really tie themselves up in knots defending the conservative justices whenever even the slightest like peek into how they operate is revealed, you know? While we're on the topic, this feels like kind of gossipy. It's a gossipy episode, right? We're talking about leaked memos. We're not supposed to see this. There's been some other Supreme Court drama, actually, over the past month or so, maybe even less. Seems like the justices are kind of out and about, various justices making speeches and appearances, and there's been some controversy. Let's start with a little bit of a Sotomayor versus Kavanaugh drama. Sonia Sotomayor made an April 7th appearance at the University of Kansas Law School. She spoke to students. She was asked questions. She did Q&A. You know, justices, this isn't like infrequent. Justices do this. Yeah. And she started to talk about, or she's asked a question about Kavanaugh's concurrence in Nome v. Vasquez Perdomo. We did an episode, right? This is the case where essentially the Supreme Court lets ICE continue to detain people, stop people, you know, investigate whether or not folks are U.S. citizens or not on the basis of like racist standards, right? This is where ICE was saying like, yeah, we stop people because they're speaking Spanish, or we stop people because they're in the Home Depot parking lot. And the Supreme Court okayed this, and Kavanaugh had that really crazy concurring opinion. He didn't even have to write it, but he was basically saying, you know, like these racist tools to stop folks, that's totally fine. He's saying, you know, if you're stopped by ICE, it's not that big of a deal. It's not that disruptive to somebody's day. These don't take very long. Just prove you're a U.S. citizen and ICE lets you go, right? And so Sonia Sotomayor in this appearance in Kansas is asked a question about this concurring opinion by Kavanaugh. And Sotomayor says that, like, this guy doesn't really understand how these stops actually affect people's lives. And she goes on, she says, this opinion is written by, quote, a man whose parents were professionals, probably doesn't really know any person who works by the hour. Which, no, wait a minute, wrong, Sonia. Brett Kavanaugh knows the guy who does his landscaping.
Mm.
So
Okay.
true.
So
true.
He knows somebody who works on hourly wages. But okay, I mean, this is hilarious.
Straight up cool as hell.
Yeah.
Coolest thing Sotomayor has done in a few years for sure.
Yes.
Possibly ever.
Yeah. This fucking rocks. She's being a girl's girl. But the quote gets out.
Of course it gets out.
Mm-hmm.
A couple weeks later, Sonia Sotomayor issues an apology. She says, quote, "At a recent appearance, I referred to a disagreement with one of my colleagues in a prior case, but I made remarks that were inappropriate. I regret my harmful comments. I have apologized to my colleague." Boo. Tomato, tomato, tomato.
We were talking about this, and at first I was like, oh, she apologized. That's so annoying because, like, she fucking cooked him, right? And now I've come around, and I think this is funnier. It's funnier to be like, he's a soft little bitch. He doesn't know anyone who has a real job, and he has no idea what he's talking about.
This silver spoon looking ass loser.
And then everyone's like, oh my God, you shouldn't really speak like that. And she's like, you know what? You're right. I'm sorry.
Right.
That's funny. That's just
and
good
she calls the comments harmful. She says she regrets making them, but she doesn't take back the substance. She doesn't say she was wrong. She doesn't say she was off
And
base.
how
She
could
says
she?
like, sorry you heard that. Sorry it hurt your feelings, buddy.
Yeah.
Yeah.
Sorry I said you went to Yale twice. Sorry I said you went to that prep school, that Georgetown, whatever, Catholic prep school where all the fucking rich psycho boys go. Sorry.
This is funny. I will say it is relatively uncommon to see someone take a public shot at another justice specifically, right?
Yes.
I'm sure that like Scalia got close to this at some point. Certainly he was insulting in opinions, right? But this is unusual for Supreme Court justices. And yeah, I don't know, maybe things are bubbling over a little bit, right? Our producer was like, is there a vibe shift going on within the Supreme Court? And maybe the answer is yes, right? Maybe these old norms are melting away because everyone is starting to hate each other so fucking much that they just can't stand it.
Right.
Speaking of things bubbling over, the soup that is Thomas's brain seems to have bubbled over and fully exited his head.
So before you get into this, Michael, I want to say I have very intentionally avoided reading exactly what Thomas said so that I can be surprised on this podcast. So I don't know.
Oh, I'm so excited. So just recently at the University of Texas in Austin.
Bree, specifically not invited to this, right? Is that
was Rhiannon the only person in the entire staff of the law school who was not invited to this speech?
So look, there might be a reason, like a sort of legitimate reason, which is like whether or not I'm listed as faculty or staff on certain lists, but every faculty member at the University of Texas School of Law got an invitation to Clarence Thomas's appearance on campus, and I did not.
Which is a shame because I would have loved to see your live reactions to this speech, where he blames like every social ill of the 20th and 21st century on the rise of progressivism. I'm just going to quote him. At the beginning of the 20th century, a new set of first principles of government was introduced into the American mainstream. The proponents of this new set of first principles, most prominently among them the 28th president, Woodrow Wilson, called it progressivism.
Dude, okay, this is deep cut right-wing shit. Right?
Yeah.
Every progressive's favorite president.
There's like a sect of right-wingers that will start talking about Woodrow Wilson all of a sudden, and you're like, what the fuck are you talking about, dude? But because of his sort of loose association with early 20th century progressivism, they're sort of going through this effort to like make Wilson part of the foundation of progressivism, of modern progressivism. I was unaware of this until like I was living in DC during the initial Tea Party rallies in like 2009. I remember just like walking by some of the protests and talking to some people, and I was just like, I'm going to go talk to these lunatics. And most people were chill, but I remember one guy ranting about Woodrow Wilson for a long time. And I was like, what are you talking about, dude?
Yes.
And then later, I think I might have told you guys this, but later I asked him to bum a cigarette. And he's like, I'll give it to you, but I'm giving this to you of my own volition. Like he was like,
Okay.
he was like, because we had been talking about like taxation or something. He was like, I like because like I like not because I have to, but because like I want to, like on my own volition. I was like, right, okay, you don't have to do. I don't need a cigarette. Actually, this is fine.
Thomas also names 4 historical figures that he says were quote unquote intertwined with the rise of progressivism. See if you can guess any of the 4.
Okay, I'm gonna go with what's her face, Planned Parenthood.
Sanger?
Yeah, Sanger. That would have been my first guess. This is all in that same phase.
He takes some historical.
Okay, he's bouncing around temporally.
Yeah,
Okay.
it's a range.
I mean, all right, I'm gonna just go ahead and say Lenin. Someone in the Soviet sphere.
So we got Margaret Sanger and Lenin. Reed, you want to give us some guesses?
I'm gonna say I'm feeling a little JFK. I feel like he's putting something on the Kennedys here.
All right.
Hold on. Let me get one more out there. Fuck, I'm gonna miss something. I'm gonna miss something obvious. I can feel it. I don't think he has the audacity to say FDR, but that would be like my actual guess. So I'm gonna go FDR.
Yeah.
You guys went 0 for 4.
Damn.
They are Stalin, Hitler, Mussolini, and Mao.
I want to say I was spiritually correct with Lenin. That's basically Stalin.
You said Soviet sphere.
Yeah.
Yeah.
Oh my God. Dude, I was like, it's not like I was intentionally being like, well, obviously I didn't say Hitler, right? Oh my God, dude.
So
that's so fucking funny.
Wow.
I love that Sotomayor had to apologize because she was like, Brett Kavanaugh's a little out of touch. And and Clarence Thomas right afterwards is like, my colleagues are Hitler. They are each like Mao.
It's incredible. It's so good. Yeah, I don't think there's much more to be
that's
said.
so
He
good,
says
dude.
this is an attack on the Declaration of Independence and the founding principles of our country. But I mean, that's the high point. That is the high point. Stalin,
You said
Hitler,
Stalin, Hitler, Mao, and who?
Mussolini.
Mussolini.
And this is
For sure.
a few years back for If Books Could Kill, I read Liberal Fascism. And the links between Mussolini and the left, I mean, it's gibberish. It's truly gibberish.
Yeah.
Like
Of course.
like all of these guys, all of like the actual fascists, right? Like the first thing they do is just go union bashing,
right?
Like arrest socialists. it's like incomprehensible when you actually understand what happened. But yeah, they love it. They love to say Mussolini was a secret lib.
Isn't that literally the first line in the poem, right? First they came for the socialists?
Yeah, I believe it might be trade unionists, but it's one of the two. I mean,
Yeah.
Oh shit.
Oh my
God, it's so good. He is a dipshit, dude. It's so funny how fucking stupid Clarence Thomas is. Remember, like I like how we're having this whole like everyone's like, oh my God, the leaked memos, the court looks so dumb, and then Clarence Thomas is like, progressives are sort of like Hitler and Mussolini, just like the dumbest Facebook post you've ever seen. He's just saying it publicly, and people are like, fascinating stuff from Clarence Thomas, who thinks that Barack Obama is sort of like Mao.
Yeah. Oh, our producer says first they came for the communists.
First they came for the communists. Okay.
Perfect.
Okay.
Perfect. Yeah.
Yeah, that dude, that's so funny. It's so funny to do like Hitler was actually progressive or whatever. That when you're like a full adult, like you're a serious, ostensibly serious kind of guy.
One of the most powerful men in the country.
Yeah. See, this is the thing about Ginny's presence in his life. It's always been there if you were willing to look, you know?
Yep.
If you knew where to look, we knew that Clarence Thomas's brain was fucking fried up. Wow. Good stuff. Next week, Brecht v. Abramson, a case about a little doctrine called harmless error. The idea that if a court makes a harmless mistake when it's prosecuting you, then your prosecution still stands. Follow us on social media at 54pod. Subscribe to our Patreon, patreon.com/54pod, all spelled out, for access to premium and ad-free episodes, special events, our Slack, all sorts of shit. We'll see you next week.
Bye, everybody.
Bye, XOXO, Gossip Girls.
5 to 4 is presented by Prologue Projects. This episode was produced by Allison Rogers. Leon Nafok provides editorial support. Our website was designed by Peter Murphy. Our artwork is by Teddy Blanks at Chips NY, and our theme song is by Spatial Relations.